He fires his public defender on the record, then tells the judge he has no contract with the court. He logs in from a car, claims COVID, refuses a doctor because it's against his religion, argues the court has no jurisdiction, and now he's facing a felony punishable by 5 years behind bars, while insisting he'll represent himself. What starts as a routine hearing spirals into a full-blown courtroom showdown, and the judge is seconds away from deciding whether this is confidence or chaos.
I don't have any contract with public defender's office.
You what? You
I
what?
don't have any contract with the public defender's office represent me.
You don't? You have a contract with them? Contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to pre-try this case.
It's going to be a Bellinger thing.
I think so.
Okay, go for it. Okay,
My
go for it.
understanding is another counsel gonna have, I believe, on this file, and I wish him good luck. But I don't see another attorney here, so I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him I would notify of any implied obligations to this case.
So you're going to represent yourself?
I'm defending myself. Correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom because I have COVID. So there's no way I could.
In a vehicle with a hat on, no mask.
I have my vehicle right now.
What'd you say?
I said yes. I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me.
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay. So here's what you're gonna do. Then I'm gonna say, okay, you got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask. If you're gonna represent yourself.
I can't make that. Is there a later date?
Yeah, you can. 3 o'clock.
3:30. I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30. If there's any issue, then
okay. And at 3 o'clock, I may issue a mentor. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because the court didn't have it.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have
3
it.
o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
And just like that, we are off the rails. He fires his public defender, represents himself, appears on Zoom from a car, claims COVID but won't see a doctor because of religion. This is the exact moment judges start tightening up. When you mix self-representation with sovereign-style arguments and procedural resistance, the court shifts from "let's clarify" to "we need control." Question for you. If you're facing a felony punishable by up to 5 years, is this really the strategy you go with?
There's no bench warrant to be issued because the court didn't have jurisdiction.
I'll determine that at 3 o'clock.
The court didn't have.
Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line.
Thank you. Your Honor, the date and time set for probable cause conference. I was appointed, I believe, yesterday on this matter. At this time, I do not have video footage discovery, so I do believe discovery at this time would be outstanding. So we would be needing another PCC date. Although given my client's in custody status, I'd ask if the court would consider a 1-week turnaround.
Is this the only thing hold?
Yes, Judge.
Your Honor, he does have a bond denied hold from the U.S. Marshals.
Oh,
Apologies, Judge. I was not aware of that.
yeah, I can tell by the look on your face. How about we go 2 weeks out? April 25th, 2024, 9 a.m. Bond continued.
And Judge, I apologize.
Okay. You can't be here.
I can't, Judge. I'm sorry.
May 2nd. Will that work?
That works for the, yes.
Okay. 9 a.m. Bond continued. Thank you.
Hold on a second. Judge, would the court allow me to address bond?
Yes.
Thank you, Judge. Your Honor, my client's 25 years old. If he were to be released, he would be residing in Ypsilanti with his parents. His father is undergoing a full back surgery on May 2nd, the date of his next court date. He is the individual who is supposed to provide care for his father during that time period. It's my understanding he has lived in Michigan his entire life. He does have ties to the community, family in the area. He also has 2 children and 1 additional child that is on the way, set to be born in the near future. He was, prior to his incarceration, enrolled in school at Post University, where he studied business administration and marketing. He's also obtained his GED. So given that, Judge, his bond is currently set at $150,000 with a 10% allowance. We would ask the court to consider a bond reduction, perhaps in the amount of $10,000 with 10%.
Response.
Your Honor, we requested $150,000 cash or surety. There was the 10% privilege given on this case. We did not think that that was appropriate at the time that it was given. Given the fact that there is a bond denied U.S. Marshals hold. The defendant is on federal probation for a weapons offense until 2025. He has a criminal history dating back to 2016, including felon in possession in 2021, assault with intent to rob in 2016, R&O in 2019, attempt R&O in 2020, a controlled substance possession case from 2019 as well as 2020, as well as some other misdemeanors mixed in. As for the specific allegations in this particular case, this incident stems from situations where the victim asked the defendant to leave her apartment. He refused, pulled a knife on her, and stuck it to her neck and threatened to kill her. She asked him again to leave later on, and then he strangled her. She was able to fight him to get him off of her, and at that point, he punched her in the face and then fled. At this point, I still would think that the 10% privilege on this is not appropriate, given that we requested for $150,000 cash or surety, and that this occurred while he was on federal probation for a weapons offense. We are significantly concerned for the safety of the victim in this case, as well as the potential threat for the greater community.
Your Honor, if I could just briefly respond. Your Honor, the people indicated that there was allegedly a knife used in this incident. I'd point out the police report does not indicate any knife was ever recovered from the scene. Further, the allegation that the complainant was strangled, there's no indication in any of the discovery I have that shows any marking or any injuries consistent with strangulation. We would vehemently dispute the allegations in this case.
Motion for bond reduction is denied, given the circumstances as well as the defendant's federal parole status. So I will deny any bond reduction. I won't increase it to the cash or security. I'll still allow 10% privilege. Thank you. Court calls the case People versus Montel Bennett.
Commissioner, I have to see your assistant prosecutor.
Matthew Mansour, Assistant Public Defender, supposed to be here on behalf of Mr. Bennett. Spoke with him last night. He was on board with the time. I think, Montel, come on. Right on time.
Your name?
Montreal Devontae Bennett.
Thank you.
Your Honor, I was just going to request a 2 to 4 week adjournment to allow Mr. Bennett to come up with the restitution amount due, then potentially plead to an offer at the district court level.
How much is the restitution?
$694.35.
How long is it going to take him to come up with that?
3 weeks.
Yes. May 2nd, 2024, 9 a.m.
Thanks, Your Honor.
Bond continue.
Court calls case People versus Jasmine Krupp.
We're ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Chuck. State your name.
Jasmine Chuck.
Thank you. What are we doing?
Your Honor, at this time, we are prepared to move forward with the resolution. Mr. Brown had the plea one in that
I don't have any plea form.
Okay.
At this time, Your Honor, the agreement is for upon successful entering of a PPO, which I have all of the pieces together. I just need to hand in to Mr. Gallagher, the judicial attorney for Judge Slay. You are reading it.
Go ahead.
It is an agreement to the misdemeanor, which is the count 2. In exchange, count 1 would be dismissed.
Count 2 or count 3?
I apologize, count 3, Your Honor. Which I believe is the malicious destruction of a building under 200. Is that correct?
No.
Would you remember?
I have that the plea form in front of me indicates that the defendant would be pleading guilty to the offense of illegal entry.
Yes.
As well as count 2, the stated count 2, which is malicious destruction of a building, 200 to 1,000, the 1 year offense. Upon her successful plea to that charge, count 1 would be dismissed. The parties are stipulating to the PPO, and the people will not object to HIDA.
That is correct.
Mr. Brown, is that the full? Has she signed an advice of verdict?
That you'll be pleading to.
Did she need to go over that more fully? Because I can pass the matter and I can get some other stuff done and then call it back up.
I understand.
Your Honor, I do want to note for the record that there is $1,137 of restitution at issue, but this resolution is not contingent upon agreement to that full amount.
Okay. Raise your right hand. Can you ever sworn?
You solemnly swear and affirm the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God. State your name.
All right. Ma'am, it is this court's understanding that you're going to be pleading to 2 misdemeanor charges. Is that your understanding? The first charge is the stated count 2 of malicious destruction of a building, 200 to 1,000. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased to 3 times the value of the destruction to the building. If that's greater than $2,000, that would become the maximum fine. You understand that? You need to speak up.
Yes.
It's also this court's understanding that you're going to be pleading to an added count 3 of illegal entry. That's a misdemeanor punishable by up to 90 days in jail and a $500 fine plus court cost. You understand that? All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court. You understand that? Now, understanding all of that, you still wish to plead guilty?
Yes.
To the charge of malicious destruction of a building, how do you plead?
Guilty.
To the charge of illegal entry, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form today, is that correct? Any question regarding any of those rights? Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of record.
Yes.
Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you? You're doing this voluntarily of your own free will?
Yes.
And because you believe that you're indeed guilty of this offense?
Yes.
On the date of January 5th, 2024, at the location of 1723 Knollwood Bend, Superior Township, Washtenaw County, State of Michigan, what'd you do on that date that makes you think that you're guilty?
Me and my ex broke up. He told me to come over.
You need to speak up.
Me and my ex broke up and he told me to come over and I accidentally busted the window.
I cannot hear her. You busted the window.
I just busted the window.
Pardon?
I busted the window.
You went to the house and busted the window?
It was an accident. Like I was banging on it and then it shattered.
It was an accident?
In my eyes, yes. It was an accident.
Well, I can't accept that plea if she's claiming it's an accident. Well, ma'am, if it's an accident, it's an accident, but that's not malicious destruction.
I busted the window.
Did you deliberately do the actions to bust the window?
I don't think I did, but I
Did you
mean, I'm just trying to
deliberately
get it
strike
over
the
with.
window?
Yes.
Okay, yeah, listen.
I'm just trying to get it over with.
Ma'am, do you want to plead guilty to this charge?
I'm just trying to get it over with.
I understand that, but I have to also make sure that you committed a crime. And if you're telling me that it was an accident, and that's what you're saying, that it's an accident, I can't accept your plea. And I understand you want to get it over. Pardon?
I busted the window.
I get that.
This right here is classic sovereign citizen style language. No injured party, fictitious entity, trust property, no jurisdiction. Here's the legal reality. Criminal cases are prosecuted by the state because crimes are considered offenses against public order. You don't need a private injured party for charges like fleeing and eluding. And jurisdiction? If the alleged offense happened in the state, the court has subject matter jurisdiction. The judge's reaction tells you everything. We haven't even reached probable cause yet, and he's filing motions like it's a constitutional symposium. Do you think this helps him or hurts him?
I can't, I'll pass it and let you speak with her, but I am not under these current circumstances. Thank you.
You don't have to talk to me like that.
Court does call the case, People versus Christopher Small. Well, now I can hear.
And there it is, the turning point. When a defendant repeatedly claims they don't understand basic procedural requirements, a judge has a constitutional obligation to ensure competency. This isn't punishment, it's protection. The court cannot move forward unless the defendant is legally competent to stand trial. But here's the twist. Sometimes defendants think these arguments show control, when in reality they trigger evaluations that pause the case entirely. Was this a calculated move, or did he just talk himself into a forensic exam?
Being with and on behalf of Chuck.
Jasmine Chuck.
All right. Had a chance to talk. I believe we are ready to go forward with the plea.
All right. Ms. Chubb, on the date and time in question, what do you do on that date that makes you think that you're guilty of this offense, of these offenses?
I busted a window.
You busted the window? All right. I'm going to ask you this because of what you said, because I have to know. You intentionally busted the window or did it in a fashion where you knew the window would break?
Yes.
All right. And did you enter the premises at that point? Pardon?
My hands were bloody, so I had to leave, go to the hospital.
And I believe in this circumstance, when she busted,
her hand went through, it broke the plane of the property.
right, that's
All right.
for the injury.
Is that correct, ma'am?
Yes.
And you don't have any ownership interest in that property?
No.
All right. And did not have the permission of the owner to enter that property or to in any way alter that property by breaking the window? All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant?
Your Honor, the defense is satisfied.
The people are satisfied. Thank you.
The court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in this matter will be
6 at 10 a.m. before Judge Barr.
June 6, 2024, 10 a.m. Judge Barr. Bond will continue. Thank you.
Good morning, Your
About
Honor.
time
Christina Costantino appearing on behalf of Jessica Yoder.
And Matthew Mansour, Assistant Public Defender, with on behalf of Ms. Yoder, for F30428.
And Your Honor, I am appearing on the other cases.
On
There's
the
three
other
of them.
three. Yeah.
Yes.
All right. What are
And
you
Judge,
doing?
Judge, I was wondering if we might briefly approach. I promise it'll be painless.
No, you won't. Yes, you may.
Thank you, Judge.
Ms. Yoder, I've got those 4 cases that you have before me today.
Mm-hmm.
And then you have 4 other cases on my misdemeanor docket.
Correct.
I think we have a resolution to all 8.
Yes.
Woohoo. So what I'm going to do is I'm going to pass the matter. We're going to get those other files down. Then we'll bring it back out and we'll try to just get it all done at one time.
Okay.
All right.
Thank you, Judge.
Court calls the case, People versus El Haji, is it Dambuya?
I guess it's close enough, Your Honor.
Okay, well, I did what I could.
Good morning, David I. Goldstein, appearing on behalf of the defendant.
Your name, sir? Okay, you can take hands out of your pockets, please. Thank you. All right, what are we doing on this case?
Your Honor, I just received the video, which is a very critical part of this discovery yesterday, so I have not had an opportunity to review it with my clients, so we're asking for a 2-week adjournment.
2 weeks. Probable cause conference, April 25th, 2024, 9 a.m. Bond continued. Court does call the case, the People versus Seth Cope.
Senior Assistant Prosecuting Attorney for the People.
Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Cope. All right. Mr. Cope.
All right, what do we do?
Honor, I'm going to request a 2-week adjournment here. Still have to go through some discovery with Mr. Cope.
That objection, April 25th, 2024, 9 a.m. Bond continued.
Thank you.
Thank you. Let's call the case, People versus Thomas Belcher.
Yes.
Assistant Public Defender Jay Bellinger on behalf of Mr. Belcher, who stands to my right. Mr. Belcher, will you please state your name for the record?
I am Thomas Ryan Belcher.
Thank you.
I would also like to fire my public defender, please.
Okay.
At this time.
Why is that?
I don't feel he's giving me proper reputation.
Okay. In what way?
He's not giving me proper reputation. He wants to adjourn it, and I've asked him not to. He won't come to see me and talk about my case at all. So
nobody's talked to you about your case?
A couple of times, but
oh yeah, okay.
I just don't feel he's fit for to represent me at this time.
Really?
Yes, sir.
Oh, that's the only objection you have?
At this moment, yes.
And it's just him? It's an office that is representing you.
I understand that. I've asked him not to have it adjourned, and he's trying to have it adjourned.
Okay, so you want it set for prelim?
I would like that, yes, sir.
Okay, is all the discovery complete, counsel?
No, Your Honor.
So you want to go to prelim without all the discovery being in and not knowing everything?
I
that
also
what you're
would like a
telling
new
me?
public defender too.
What? Well, you'll have to deal with their office regarding that, but he's here. He's qualified, he's representing you. He's trying to actually protect your interest by not setting the exam where he doesn't have all of the information to be able to adequately discuss it. But I presume with your law degree, you decide you want to do it some other way.
I actually do not have one.
Yeah, that's what I thought. Kind of knew that. That's why you should probably let him handle it. Did you want to see all your discovery or you just want to go to exam?
I would like to see it.
What?
I would like to see the discovery.
Okay, so the only way that's going to happen is by following exactly what counsel wants to have happen to adjourn it so he can get it all, sit down and talk with you. Does that make sense?
It does, yes.
Yeah, it sounds probably the same thing he said to you. You'll just take it from me, but you won't take it from him. That makes no sense. Maybe instead of talking, you ought to start listening. Your motion to fire counsel is denied. Counsel, you want an adjournment?
Your Honor, we would just be asking for 2 weeks. There is an investigation finishing up in our division.
April 25th, 2024, 9 a.m. so that you can get all of the information and talk to your counsel, to your client. Thank you. Bond continued.
Colonel, was there a finding on competency?
Oh, you know, actually, I believe
there is. They bring him back.
That up.
I just want to make sure before we.
No,
I don't know that. Did we do the finding? I thought we had.
If you did.
No, we did not.
No, it's okay. It's not your fault.
The report indicates that he's competent.
And Your Honor, we have reviewed that. I do have
to hear what happened today. But anyway, never mind. Go ahead.
We've been able to review that. Have given Mr. Belcher a copy of that as well. We would stipulate to the findings.
People also stipulate to the finding. Defendant is found competent to stand trial in this matter. Court specifically would indicate that the defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is deemed competent. Counsel, please file an order, and I'll set the probable cause for the time that I set on the 25th. Bond continue. Thank you. Thank you.
One second, Mr. Demond, that's your notice for your next.
Court calls case People versus Tariq Day.
The Michigan Senior Assistant Prosecuting Attorney for the People.
Hello, Tariq Samar, Tariq Day here.
Already, Judge. Courtroom Fleischer, Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera?